So my fellow panelists have done the hard work of laying out the details of this case. Thank you to them for that. I think I now have the luxury of stepping back a bit and making some more big picture points. And Sean, if it makes you feel any better, I don't have any PowerPoint at all. So. Is it working? They can hear me. Yeah. Is it working?
Is it?
Yeah,
Oh, good.
there it is.
You may want to-
That way. Okay. So I'm going to talk about three things. I'm going to talk about patent policy. I'm going to talk about the international law of patents and how it relates to international investment law. And I'm going to talk a bit about the role of international courts. Let me offer a caveat, especially in relation to patent policy. I'm not an IP expert. I never took any intellectual property classes in law school. It may very well be that I know less about IP than anybody in this room. So I won't be offended at all if afterwards people offer criticisms and clarify some factual errors I've made. Please feel free to enlighten me. Let me start by talking about a patent. So the promise doctrine, which we've just heard a lot about, Andrew explained it. I always have trouble understanding it. When somebody explains it, I have it in my mind for about an hour. After that, if you ask me tomorrow, I'm not going to be able to tell you what the promise doctrine is. The origin of this doctrine, to me, is very perplexing. Where did this come from? Why did the Canadian courts pick it up? Is Canada the only one doing it? I don't have answers to any of these questions, but my theory is that the promise doctrine, as set forth by the Canadian courts in these cases that we're talking about, is not really about the promise doctrine at all. It's really about a larger patent policy issue. It was a way for the Canadian courts to get involved in a larger fight about patent policy. So as a comparison, in U.S. constitutional law, the Second Amendment, as I vaguely recall it, over the years, there have been many scholars arguing that there's an individual right to bear arms. And eventually, the Supreme Court picked up on this and agreed. I don't have the sense that there was something similar going on, that for years and years, there were scholars out there saying, we need a promise doctrine, and finally, a court picked up on it. I think that it's something more, simpler. And I think Burju referred to a lot of these issues. Many people think that pharmaceutical drug prices are too high because of patent monopolies. And the promise doctrine was a way for the Canadian courts to undermine patents and bring down prices. The courts don't have the ability to address this issue head on. They can't just say no more patents or patents should be for a shorter term. This is a way for them to get at it at the margins, get at the issue at the margins. But it's only at the margins. And I think these court cases actually give us a great opportunity to talk about the underlying policy issues. What we really need is more debate about patent policy. So the argument for giving patent monopolies is that they spur innovation. They give companies incentive to innovate because they can apply for patents and then get rich. And not just the normal rich that businesses get. This gives you above market prices, and you can get above market rich. You can get really rich. So does this work? Does this create more innovation? And you'd think the answer might be yes. But surprisingly, there are a number of economists who looked at this and said, actually, no, this doesn't lead to more innovation. Now, I'm going to stay out of that argument and let the economists fight it out. But I think it's worth pointing out there is some doubt that patent monopolies actually give us more innovation. To get into some of the details, one key part of this, all this debate is the appropriate length of a patent term. So it used to be 17 years in the United States, and then with the TRIPS agreement, it was shifted up to 20 years, and that's now the standard around the world. But why is it 20 years? I've looked into this a bit and looked at what economists said about it, and I can't find any support for this. It does not seem to be an evidence-based standard that there were all these studies done and 20 years was decided to be the right amount. And then beyond that, why 20 years for everything? Is as part of my research onto this, actually this was just something I happened to notice in the newspaper. In 1969, somebody got a patent for the game Twister, where you spin the little dial and you put your right hand on green. Somebody got a patent for this, 17-year monopoly on having this game. And what struck me is that the patent term is the same for Twister as it is for a cure for cancer. Does that make any sense? I mean, shouldn't we distinguish a bit between the value that different patents are giving? So I think we need to have a public debate about these issues. How long should patent terms be? And should we distinguish between different types of inventions? And to me, that's what the Canadian court decisions are really about. Nobody will talk about these larger issues, and somebody in the Canadian judiciary was frustrated by it. So they thought, hey, here's an opportunity to step in at the margins and force the issue. Now, maybe that's reading a little too much into it, but I have heard enough, commentary about this case to suggest that maybe there is something to that. So I think that exhausts my knowledge of patents. So let me now talk about the international law aspects of this case. As Sean and others have pointed out, so we've got a bunch of international law here. We have patent cooperation treaties. We have the TRIPS agreement. We have NAFTA. We have all these bilateral free trade agreements, and they all have intellectual property chapters and provisions, and they have specifically provisions on patents. So there's lots of international law out there. And some of it is enforceable. If a government doesn't like what another government is doing in the area of patent policy, they can bring a complaint under agreements that are relatively enforceable as international law standards go. But as we also know, there's more to that, to the Eli Lilly case than just the intellectual property provisions of these agreements. This case is about what I refer to as some constitutional or administrative law type provisions that are in the NAFTA investment chapter. And the complaint really relies only indirectly on intellectual property law. So in essence, the claim is that because of what Canada is doing with its intellectual property, with intellectual property law, the Canadian court rulings constitute expropriation and also treatment that's not fair and equitable. It strikes me that this is sort of like an argument in the domestic context that if a court invalidates a patent, then it is engaged in regulatory expropriation under the takings clause. I've wondered if there are any cases out there like that. Maybe somebody in the room knows, but it strikes me as that's the parallel. That's the domestic law parallel. So I think what this does, I think this gives us an opportunity to think about the relationship of international intellectual property law and international investment law. And the way they've come together in this case, I think, could lead to some problems. First of all, if you look at the TRIPS agreement and the NAFTA intellectual property provisions and the FTA intellectual property provisions, the governments who drafted these agreements did not give a private right of action. They explicitly set out rules that were designed to be subject to state-to-state dispute settlement. That was intentional. They could have created a private right of action. They didn't. And I think we need to respect that, respect the way that those agreements were drafted. And the expansion of international intellectual property law in the way that's being done here, if we can bring international intellectual property law into the investment law system, that's a major policy shift. And I think, in some loose sense, I think, shouldn't the people have a say in this? Shouldn't there be a public debate about the implications of this? If we have the judiciary take on this shift, on its own without sort of checking with the governments, to me that kind of goes too far. Second, I wonder whether the international investment law folks who will be hearing these cases really have the expertise to deal with these issues. I know my limitations in intellectual property law. I don't feel qualified to make definitive judgments on these issues. But we've got this investment arbitration system out there that it sort of uses people who are very smart but not necessarily intellectual property experts to decide these cases. Are they going to be able to weigh in and give credible decisions on these very technical areas? And then finally, what if an international investment tribunal interprets the patent law provisions of the NAFTA or the WTO, the TRIPS agreement, differently than, say, a parallel case of the WTO? We have this problem of fragmentation of international law that scholars have been writing about. Does this just add to it? We're going to have conflicting decisions about the promise doctrine in an investment tribunal and a WTO panel. It contributes to this problem. So it's not clear to me that intellectual property fits very well into the investment law system, especially when we already have an international intellectual property system out there. We already have this system. Why aren't we using it? Why graft it onto this other system? But as Sean mentioned, we've got other cases related to tobacco as well. So these cases look like they're going to go forward, and we'll have to see how it plays out. It may not be the disaster that I fear, but I am concerned about these things. Let me now make a sort of even more general point about the role of international courts. So what we have here are decisions of the Canadian judicial system, starting with the lower courts, but eventually working their way up to the system, and the Canadian Supreme Court had the opportunity to weigh in here and decided not to take the appeal. So, in a sense, the Canadian Supreme Court has weighed in here, at least for the moment, and has endorsed what the lower courts are doing. So I think we can all agree, when you talk about the levels of court, Supreme is pretty high. That's usually the top one. That's the case here. And normally, if you have a Supreme Court decision, that's the end of the matter, unless the legislature or the people, through a constitutional amendment, and everybody's system differs a little bit, unless they want to weigh in and overturn it. So normally, it's the Supreme Court gets a final word. But apparently, there's an international court system above the domestic Supreme Court system. And did anybody know that? You look at, I tend to focus more on the U.S., but also in Canada. So did the U.S. Congress know that when it signed on to these investment treaties, U.S. Supreme Court decisions would be subject to review by an international court? And there are cases out there, and the people in the audience probably know better than I do, about software patents. I mean, there's some chance, or there was some chance, that the U.S. Supreme Court would invalidate software patents to some extent. And the question is, if they did so, could that decision be appealed to an investment tribunal if a foreign owner of software patents was affected by this? And I think the answer is yes. And so my question is everybody okay with that? Because that's kind of a big deal. And I don't want to suggest that I would never go along with that, but I think we need to have a public debate about the implications of that. We tend to disguise what's going on with these investment tribunals. It's just about investment arbitration, it's about arbitrating investments. It's actually about major public policy areas, constitutional type provisions, and it involves important questions of sovereignty. And I don't want to come out too strongly on one side or the other, but I want to have that debate. And I think we've kind of slipped these provisions in without having the debate, and I think that's what leads to problems, when everybody suddenly realizes that domestic Supreme Court decisions can be appealed to what kind of looks like an international Supreme Court. If we're going to set up an international Supreme Court, I think we need to talk about what is its mandate? What kind of claims will it hear? Who are the judges that are going to be on this court? How do they get picked? Those are important questions. We haven't answered them, even though we've gone down this road and we have what looks like an international Supreme Court. Just one final point. So news reports have suggested that in the Canada-EU trade agreement that is almost done being negotiated, one of the holdups is Canada's fear that it will get similar complaints from European patent holders, and they're trying to tweak the language of that agreement to make sure that these kinds of decisions can't get challenged under the investment provisions of that agreement. It's hard to tell too much from short news articles about these things, but what I've seen written is that the only changes are going to be that no claims can be made based on the expropriation obligation. But there's more than just expropriation at issue. There's also this more general provision of fair and equitable treatment. So what occurs to me is that these slight tweaks that Canada wants to make to prevent future cases being brought by the Europeans are probably not enough. And then I think we need to have a broader conversation about investment law generally. And in Europe, they are sort of having that right now as part of the TTIP negotiations. But I think we really need to go further, go to the core of this, and think about what does it mean to have an international court looking at issues of expropriation and regulatory expropriation and due process type claims like fair and equitable treatment. Let me leave it there.